For a group of people who spent 4 years obsessed with law and order, it is genuinely astonishing how bad they are at actually following the law. I mean, seriously, think back to January 20th. Day one, the pomp, the circumstance, the gold curtains. We saw Donald Trump sitting at the Resolute desk, holding up those executive orders like trophies. He was signing away rights, signing away regulations, signing away the future of the planet with that black Sharpie, looking at the cameras with that smirk that says, I can do whatever I want. He thought he was emperor. He thought the election was a coronation. He thought that because he won, the rules no longer applied to him. Well, I hope he enjoyed that moment, because a federal judge in Massachusetts just woke him up from that little daydream with a bucket of ice water. In a ruling that just came down, and we need to talk about this because the mainstream media is going to frame this as a setback, when in reality it is a catastrophe for this administration. Judge Patti Saris didn't just block Trump's ban on wind energy, she shredded it. She took the flagship policy of his drill baby drill agenda, looked at the legal arguments behind it, and essentially threw them in the trash. And she did it with 5 words. 5 brutal, specific, legal words that you need to memorize because they are the reason this administration is going to lose over and over again. Arbitrary, capricious, and unlawful. That is the kill shot. Now, if you aren't a lawyer, that might just sound like technical jargon, but let me translate that for you. When a judge calls an executive order arbitrary and capricious, they aren't saying, I disagree with your policy. They aren't saying, I think wind farms are pretty. They are saying, you made this up.
They are saying, you have no evidence. You have no data. You have no justification. You just woke up, decided you hate windmills because they ruin your view at Mar-a-Lago or Scotland, and tried to legislate your personal grievances into federal law. That is what Judge Saris found. She looked at the Trump administration's attempt to halt all wind leasing on federal lands and waters, an order that paralyzed billions of dollars in investments and threatened thousands of jobs, and she realized there was nothing backing it up. No economic impact study, no environmental review, just a vibe, just an impulse. And in a courtroom, impulses don't count. Letitia James, who, let's be honest, is living rent-free in Donald Trump's head at this point, led a coalition of 17 states to fight this. And they didn't just win on a technicality. They won on the merits. The judge vacated the order nationwide. That means the ban is gone. It is dead. As of right now, the Bureau of Ocean Energy Management has to get back to work. This is the part that is so incredibly embarrassing for them. They had 4 years to prepare for this. They had the Heritage Foundation writing Project 2025. They had legions of lawyers. And yet on the very first big test of their power, they face-planted. They were so arrogant, so convinced of their own invincibility that they didn't even bother to do the basic homework required to make a policy stick. It's sloppy. It's lazy. And frankly, it exposes the weakness at the heart of this entire presidency. They want to rule by decree, but they are too incompetent to navigate the bureaucracy they want to dismantle. But don't think for a second that this stops them. This was a humiliation, yes, but it was also a signal. They tested the fence, and they got shocked. Now they are going to try to figure out how to cut the power. We need to look at exactly how they failed, because the stupidity of this order actually hides a much darker intention.
Crime against logic, a crime against process, and a crime against the basic function of government. To understand why Judge Saris tore this order apart, we have to put on our forensic gloves and look at the weapon she used. It's a piece of legislation that doesn't get a lot of headlines. It's not sexy, it doesn't fit on a bumper sticker, but it is quite possibly the only thing standing between us and a total autocracy. It's called the Administrative Procedure Act, or the APA. Passed in 1946, the APA is basically the constitution for the federal bureaucracy, and it has one golden rule that every first-year law student knows. But apparently, the White House counsel forgot. You cannot govern by "because I said so." The APA says that federal agencies, and by extension, the orders directing them, cannot be arbitrary and capricious. That is the magic phrase. It means that if the government wants to do something, especially if it wants to change something big, It has to show its work. It has to look at the data, consider the evidence, and offer a reasoned explanation for its actions. This is where the Trump administration walked into a trap of their own making. See, when you enter office, you have the power to change policy. Elections have consequences. We know that. If Trump wants to pivot away from green energy, he technically has the authority to steer the ship in that direction. But the Supreme Court, and I'm talking about the Supreme Court in Motor Vehicle Manufacturers Association versus State Farm, a case from 1983, established a very clear standard. They ruled that an agency changing its course must supply a reasoned analysis for the change.
You can't just flip the switch. If you spent 4 years saying wind energy is safe and vital, and then on Tuesday you say wind energy is dangerous and illegal, you have to explain what changed. Did the physics of wind change? Did the economics collapse overnight? Did a wind turbine sprout legs and attack a city? No. The only thing that changed was the guy sitting in the chair. And under the APA, I'm the new boss and I hate windmills is not a valid legal argument. Let's look at the executive order itself. This was issued on January 20th. It wasn't a nuanced policy shift. It was a sledgehammer. Section 2 of the order directed the Secretary of the Interior to indefinitely suspend all new leasing for offshore and onshore wind energy development. Indefinitely. That's not a pause for study, that's a moratorium. That is a ban in everything but name. Now, imagine you are Letitia James, the Attorney General of New York, or Maura Healey's team in Massachusetts, or any of the 17 AGs who sued. Your states have spent years planning their energy grids around these offshore wind projects. You have signed contracts. Companies like Ørsted and Equinor have invested billions. Factories are being built to manufacture turbine blades. Ports are being dredged. The economic reliance interests, that's the legal term, are massive. And then, with one signature, the president tries to torch it all. When the states took this to court, they argued that the administration failed to consider these reliance interests. The administration ignored the factual findings of the previous 4 years. Findings that showed wind energy lowers costs, reduces pollution, and creates jobs. They ignored the Department of Interior's own scientific records. And what was the Trump DOJ's defense? This is the part that is truly mind-blowing. Their defense was, essentially, the president has broad discretion to manage federal lands. That's it. That was the argument. He's the president, he owns the land, deal with it.
Judge Saris looked at that argument and dismantled it piece by piece. She pointed out that while the president has discretion, that discretion is not absolute. It is bounded by the law. You cannot ignore the statutes that created the leasing program in the first place. Statutes like the Outer Continental Shelf Lands Act, which specifically mandates that the government develop these resources to meet the nation's energy needs. You cannot just decide to not enforce the law because you don't like it. That is the definition of arbitrary. The ruling highlights that the administration failed to provide any contemporaneous evidence justifying the ban. They didn't produce a study showing that wind farms kill whales, a lie Trump loves to repeat, but his lawyers were smart enough not to put in a sworn affidavit. They didn't produce a study showing that wind energy hurts the grid. They produced nothing. This is the fatal error I'm talking about. It's laziness born of arrogance. If they were smart, and thank God they aren't, they would have done this differently. They would have launched a review. They would have bogged the industry down in red tape. They would have appointed a blue ribbon commission to study the impacts for 2 years, effectively stalling the industry without technically banning it. That is how a competent authoritarian dismantles a program. You death by 1,000 cuts it. But Trump doesn't want a review. He wants a headline. He wants the visceral satisfaction of saying, stop. He wants to go to a rally and say, I killed the windmills. So he chose the blunt instrument. He chose the executive order. And because he chose the blunt instrument, he ran headfirst into the Administrative Procedure Act. The court's decision to vacate the order is significant. Often, judges will remand without vacation, which basically means you messed up the paperwork. Keep the policy in place, but go fix the explanation. That's a slap in the wrist.
But Judge Saris vacated it. She said the error was so fundamental, so core to the legality of the action, that the order cannot stand for even one more second. She wiped it off the books. Why? Because the deficiency, the lack of a reasoned explanation, wasn't just a clerical error, it was the whole point. There is no reasoned explanation for banning wind energy in 2025. The economics are sound, the technology is proven, the climate necessity is urgent. The only explanation is political spite, and you can't write political spite in the Federal Register. So they wrote nothing, and they lost everything. This forensic analysis reveals something crucial about the people currently occupying the White House. They are not legislative masterminds. They are vandals. They know how to break things, but they don't know how to build the legal framework to keep them broken. They treated the U.S. Code like a suggestion box. They treated the Administrative Procedure Act like a nuance they could ignore. They thought that the sheer force of Trump's personality would be enough to override 50 years of administrative law. But here is the rub. While we can laugh at their incompetence today, and we should, because it is objectively funny to watch high-priced DOJ lawyers get spanked by a district court judge, we have to recognize that this is just the first skirmish. They were lazy this time, they were sloppy this time, but they are going to learn. They are going to read this ruling, they are going to see exactly where they failed. And the next time they try to gut a federal agency or ban an industry they don't like, they are going to come back with better paperwork. They're going to come back with sham studies. They're going to come back with reasoned explanations that are technically sound, even if they are morally bankrupt.
This case was not just a legal battle, it was a stress test of the system. The system held. For now. But we need to look at the pattern of behavior here, because this isn't just about windmills. This is about a philosophy of government that views the law not as a set of rules, but as an obstacle to be crushed. And if you think they're going to stop at wind energy, you haven't been paying attention. This same arbitrary and capricious mindset is being applied to healthcare, to education, to civil rights. They are throwing everything at the wall to see what sticks. Let's zoom out and connect these dots, because when you see the full picture, incompetence starts to look a lot like a strategy of chaos. This wasn't an accident, and honestly, it wasn't even really a mistake. If you think this was just a clerical error or a bad day at the office for the White House counsel, you are missing the forest for the trees. We have to zoom out. We have to look at this wind ban not as an isolated incident, but as a data point in a much larger, much more dangerous graph. Because when you connect the dots between this executive order and everything else we have seen since January 20th, a terrifying picture starts to emerge. This is the spaghetti strategy. They take a handful of half-baked, illegal, unconstitutional ideas that they know won't pass a basic legal smell test, and they throw them all against the wall at the same time. They flood the zone, they overwhelm the courts, they exhaust the opposition. Think about it. While we're all focused on the wind ban getting struck down in Massachusetts, what else is happening? They are dismantling the Department of Education. They are purging the civil service under Schedule F. They are attacking the independence of the Federal Reserve. They are issuing orders on immigration, on healthcare, on trans rights, on tariffs.
They create a blizzard of chaos, and they know that the legal system, by its very design, is slow. It is deliberate. Judge Saris moved fast, yes, but how many other judges are bogged down right now? How many other destructive policies are slipping through the cracks while we celebrate this one victory? This is asymmetric warfare against the rule of law. The wind ban was sloppy, sure, but it fits perfectly into the Project 2025 playbook. We warned you about this. We read the 900-page manifesto so you didn't have to. And on almost every page, the philosophy was the same. The president is the king, and the experts are the enemy. The reason they didn't have a reasoned explanation for the wind ban, the reason they didn't cite scientific data, is because they don't believe in scientific data. To them, data is just a tool of the deep state. To them, a career scientist at the Bureau of Ocean Energy Management who says, actually, sir, wind energy is profitable, is not a public servant doing their job. They are a traitor to the MAGA agenda. So they ignore the experts. They bypass the process. They treat the Administrative Procedure Act not as a law to be followed, but as a shackle to be broken. Remember Steve Bannon? Remember his stated goal years ago? The deconstruction of the administrative state. That is exactly what we are watching in real time. The wind ban wasn't just about wind. It was an attempt to prove that the president's will is superior to the agency's process. They tried to break the machinery of government. They tried to prove that they could turn off an entire industry just because the leader felt like it. And here's the darkest part of this pattern. They learn.
We saw this in the first term. Remember the Muslim ban? The first version was a mess. It was chaotic, it was illegal, and it got blocked by the courts almost immediately. We cheered, we went to the airports, we thought we had won. But what did they do? Did they stop? Did they say, oh, our bad, we'll respect the Constitution now? No, they went back to the drawing board. They watered it down, they tweaked the language, they hired better lawyers, and eventually, a version of it passed the Supreme Court. That is the danger here. This ruling by Judge Saris is a speed bump, not a brick wall. Right now in some basement at the Heritage Foundation or the America First Policy Institute, there are lawyers reading Judge Saris's opinion. They aren't crying, they are taking notes. They are highlighting every sentence where she explained why they lost. And they are drafting Wind Ban 2.0. They are figuring out how to fake the reasoned explanation. They are commissioning the sham studies. They are finding the fringe scientists who will write whatever conclusion they are paid to write. They are preparing to paper over the arbitrary and capricious whole with a veneer of fake legitimacy. This is a pattern of relentless bad faith. They don't care about governing, they care about ruling. And there is a difference. Governing means working within the system to improve the country. Ruling means forcing the country to bend to your will regardless of the consequences. Look at the response to the ruling. Did you see a statement from the White House respecting the judicial process? Did you see them say we disagree, but we will follow the law? No! You saw attacks on the judge. You saw tweets calling the court biased and corrupt. You saw the delegitimization of the very institution that is meant to hold them accountable. This is the authoritarian two-step. Step 1, break the law. Step 2, if you get caught, attack the law itself.
They want you to believe that Judge Saris isn't a neutral arbiter interpreting the APA. They want you to believe she is a political operative. They want to erode your faith in the courts so that the next time they ignore a ruling, you won't care. This is gaslighting on an industrial scale. They are trying to convince you that their arbitrary whims are democracy and that the law is tyranny. And honestly, it's terrifying how effective it can be if we stop paying attention. Because while this wind ban failure is a moment of relief, it is also a flashing red warning light. It shows us that they are willing to try anything. They have no shame, they have no respect for precedent, and they have absolutely no intention of playing by the rules. They are testing the fences. They are looking for the weak spots. And if we think that one district court judge in Massachusetts can hold back the tide forever, we are deluding ourselves. Because the ultimate goal isn't just to stop wind farms. The ultimate goal is to get to a point where they don't need a reasoned explanation for anything, where the "because I said so" is the law. And that brings us to the stakes. Because if they succeed, if they refine the strategy, if they pack the courts, if they wear us down, we aren't just losing wind turbines, we are losing the republic. So where does this leave us? We caught a break today. A federal judge did her job, the system worked, and a disastrous policy was stopped in its tracks. It is tempting to take a victory lap. It is tempting to look at this ruling, meme it, laugh at the incompetence of the Trump administration, and move on. But that would be a fatal mistake. Because we need to be crystal clear about what the stakes really are. This wasn't just a fight about wind turbines. It wasn't just a fight about renewable energy versus fossil fuels. This was a stress test for American democracy. And we came dangerously close to failing it. Ask yourself, what if Judge Saris had ruled the other way? What if she had been one of the dozens of ultra-conservative judges appointed in the last term, someone more interested in fealty to the unitary executive than in the text of the Administrative Procedure Act? If this order had stood, it would have established a terrifying precedent. It would have established that the President of the United States can wake up on a Tuesday, decide he has a personal vendetta against an entire sector of the economy, and wipe it out with the stroke of a pen, without evidence, without data, and without reason. If he can do that to the wind industry, do you really think he will stop there? If arbitrary and capricious becomes the standard of the land, what is to stop him from banning electric vehicles because he thinks they are woke? What is to stop him from withholding disaster aid to blue states because they didn't vote for him? What is to stop him from revoking the licenses of media companies that criticize him? This is the nightmare scenario. This is the dictator on day one promise coming to life. We are looking at an administration that views the rule of law not as a guardrail, but as an enemy combatant. And let's talk about the economic suicide of it all. While Trump plays these petty political games, the rest of the world is moving on. China isn't banning wind energy. They are building it faster than anyone on Earth. Europe isn't debating the existence of climate change. They are retooling their entire economies to survive it.
By trying to kill this industry, Trump isn't saving America. He is sabotaging our future. He's telling the world that the United States is closed for innovation. He's telling investors that their money isn't safe here because a temper tantrum in the Oval Office could wipe out their assets overnight. He is trying to turn the American government into a protection racket for his friends in the oil and gas industry while leaving the rest of us to burn. We got lucky this time. We had Letitia James, we had the APA, we had a judge who believes in the law. But luck is not a strategy. The folks behind Project 2025 are banking on one thing above all else: your exhaustion. They want you to get tired. They want you to look at the constant chaos, the endless lawsuits, the daily outrages, and check out. They want you to say it's too much and turn off the news. That is how they win. They win by attrition. They win when we stop paying attention to the details. They win when we stop noticing that arbitrary and capricious is slowly becoming standard operating procedure. So here is the reality check. This fight is just beginning. The wind ban was the opening salvo. They are going to come back. They are going to try again. They are going to attack the EPA, the Department of Education, the FDA, the Civil Service. They are going to try to dismantle the administrative state brick by brick until there is nothing left but the whim of the leader. We cannot afford to blink. We cannot afford to be cynical. We have to be as relentless in defending the rule of law as they are in attacking it. Support the attorneys general who are fighting these battles on the front lines. Support the journalists who are reading the fine print. And most importantly, do not let them gaslight you into thinking this is normal.
It is not normal to govern by impulse. It is not normal to ignore science. It is not normal for the president to act like a king. Judge Saris reminded us today that the law still matters. The words arbitrary, capricious, and unlawful still have power, but they only have power if we demand it. They only have power if we refuse to accept a government that rules by decree. The wind is back in our sails for now, but the storm is far from over. Stay angry, stay focused, and for the love of democracy, do not look away.